Alors, bonjour tout le monde, content de vous retrouver. Je me présente Louis-Philippe Lampron, je suis membre de l'Observatoire de la liberté d'expression et du CRIDAQ, qui sont les deux centres de recherche qui organisent la conférence d'aujourd'hui. Alors, merci à Stéphanie Tremblay, directrice du CRIDAQ, Geneviève Newtons, directrice de l'Observatoire, qui sont ici avec nous. Et donc, on a le très, très grand plaisir de recevoir aujourd'hui Katie Fallow, qui est membre du Knight Institute for First Amendment, qui est rattaché à l'Université Columbia. Donc, dans le contexte sociopolitique actuel, la raison pour laquelle on a le plaisir de recevoir Katie Fallow, ça s'inscrit notamment dans un déplacement que j'ai eu la chance de faire avant que ce ne soit plus possible pour moi de le faire, considérant mes propos critiques sur les réseaux sociaux. Je suis allé donc cet automne aux États-Unis pour suivre notamment la campagne présidentielle américaine, puis regarder l'impact des nouvelles technologies, de la désinformation sur cette campagne présidentielle-là. Et dans ce contexte-là, j'ai eu le plaisir de participer à certains des travaux du Knight Institute for First Amendment et de rencontrer donc Katie Fallow. Et donc, le Knight Institute est un institut important aux États-Unis qui est dédié à quelque chose auquel on est peut-être un peu moins fréquemment exposé au Québec. En fait, c'est l'idée du contentieux stratégique, en fait. Alors, je vais évidemment pas vendre le punch puis laisser la conférencière vous présenter ce qu'il en est. Mais grosso modo, c'est un institut qui allie la recherche sur la liberté d'expression et les corollaires à la liberté d'expression avec une branche dont elle est une des responsables qui est dédiée à choisir des cas et à les porter devant les tribunaux de telle manière qu'à assurer vraiment là, une mobilisation des connaissances puis assurer un renforcement stratégique, justement, de cette liberté fondamentale au fonctionnement des institutions démocratiques. Alors, voilà pour la petite mise en contexte. Maintenant, sans plus attendre, et là, c'est terrible parce que j'ai imprimé la description donc du CV de la conférencière sur mon téléphone et je réalise que je vais avoir besoin de foyer bientôt parce que c'est très petit. Alors, vous allez m'excuser, là, les grimaces qui vont m'amener à lire, justement. Donc, alors, Katie Fallow est le fer de lance des litiges de l'Institut concernant, on parle du Knight Institute, l'utilisation des médias sociaux par le gouvernement et à ce titre a été l'un des principaux avocats dans l'affaire de l'Institut concernant le blocage par le président Trump des personnes de son compte Twitter X au cours de son premier mandat, donc en 2016-2020. Avec ses collègues, Katie Fallow a déposé un certain nombre de recours juridiques contre certaines actions de l'administration Trump. Donc, avant de rencontrer Katie, je parlais de Trump 2.0, mais c'est quelque chose de trop noble, en fait, et donc, elle m'a suggéré de parler de Trump 2, ce qui est franchement mieux, parce que là, on a l'impression de voir un peu l'Empire contre-attaque, un mauvais film, en fait, qui revient, puis je trouve que ça colle bien à la situation. Alors, de l'administration Trump 2, qui menaçait la liberté d'expression et la liberté personnelle. Dans sa conférence, elle abordera l'importance du contentieux stratégique dans le cadre d'un institut dédié à la protection d'une liberté fondamentale comme la liberté d'expression et ses corollaires, ainsi que les défis auxquels est confronté un institut académique comme le sien dans le contexte politique que nous vivons depuis l'entrée en fonction de cette administration Trump 2. Sur le fonctionnement de la conférence va avoir lieu en anglais, mais grosso modo, dans la séance qui va suivre, en fait, parce qu'il va y avoir une période d'échange avec vous. Vous allez être tout à fait libre de poser votre question en français, donc je serai en mesure de traduire la question et même la réponse, là, si tant est que voilà, qu'elle soit assez concise. En tout cas, au moins l'esprit de la réponse qui sera donnée par Katie Fallow. Alors, sans plus attendre, je cède la parole à notre conférencière et je vous souhaite une bonne conférence.
Merci beaucoup. Bonjour, ça va? No, I don't actually speak French, other than a little bit I learned in high school. But Louis-Philippe said that I would get a lot more cachet if I spoke French, so I'll try to pepper a few Frenchisms in there. So thank you very much for having me, and I know that for better or for worse, or probably for worse, all of the world is very familiar with a lot of the stuff that's going on in the United States and under Trump 2 or Trump 2.0. And so what I wanted to do was to talk about both the background of the Knight Institute and how we came into being and kind of what is our role and how do we set up our role as a strategic litigation advocacy organization, and talk about some of the work that we did under the Trump, is this loud enough? Too loud? Okay. Under the first Trump administration, which at this point I think of as the before times and the normal times, although when he first came into office, it was actually also very norm-busting and unusual, but how we litigated First Amendment cases in the first Trump administration, and to talk about some of our specific cases that we've brought, and kind of use that to explain the kind of work that we do and what we're trying to achieve, and then also talk about what we've done in the this is the 100-day anniversary, or the 100 days of first 100 days of Trump's second administration is today. So. The Knight First Amendment Institute was established in 2016, and it was established as kind of a joint project by a philanthropic organization called the Knight Foundation, which has the money from a former media empire of the sort of mid-20th century of newspapers and broadcast television stations. And so the Knight Foundation gives a lot of money to free expression and civic engagement and democratic building efforts. And then it was also, so it was the Knight Foundation and Columbia University. And the former president of Columbia University, Lee Bollinger, was a First Amendment scholar in his own right and very interested in First Amendment issues. And so they both pledged a significant sum of money to endow and support an independent institute, and I mean independent in the sense that it is not tied to any specific school at Columbia University. So it's not part of the law school, it's not part of the journalism school, although we do work with those programs, but it is called an institute, and it's independent to a great degree. We have a board of directors that some of our members of the board are the head of the law school, the head of the journalism school, the president of Columbia University, but also individuals who have worked in free expression and press freedoms for a while. And the sort of founding mission, or the sort of the motivation behind the founding of the Knight Institute, was in part conceived by the president of the Knight Foundation, and again I was saying from this newspaper television empire, and it was in recognition that in the 2016 there was a very robust First Amendment law that had been established by the Supreme Court during primarily the 20th century, and a lot of the really important cases interpreting First Amendment rights in the United States had been brought by newspapers, and they were kind of at the forefront for fighting, for example, to protect the ability of newspapers to report on important issues without fear of crippling defamation lawsuits. So there's very strong protection for defamation, and also newspapers that were arguing to protect the right of newspapers to, for instance, publish classified information that had been leaked to them, and even if the act of leaking was a criminal act, that the idea that you should still protect the ability of the press to publish that information because it's in the public interest. But the Knight Foundation also recognized that the newspaper industry and to some extent broadcast television had been but the newspaper industry had been decimated by the internet. And so the newspaper industry has really just, completely gone off the cliff essentially financially, and it's hard to, that's why you see, Jeff Bezos owning the Washington Post, or basically you're relying on, billionaires to buy newspapers, and that, as we know, has its pluses and minuses. But so they wanted to establish an institute that would fight for these press and speech freedoms without, being limited by financial constraints. And so our broad mission, the other thing is to focus on, fighting for free speech and press freedoms, but also to use these Supreme Court precedents that were established in the 20th century and apply them to free speech problems or issues presented in the digital age. So essentially to focus on strengthening and protecting free expression in the digital age. And we have three programs that we do, which is strategic litigation, and that's what I do. I'm a litigator, and I have a background before I came to the Knight Institute of working at a law firm for many years and also in the government, where I particularly focused on First Amendment and free speech issues. We also have a research branch that publishes academic articles and shorter pieces and host symposiums, and we try to sort of interconnect both our litigation and our research work. And then we have a public education branch through podcasts and our website, and providing government documents, for example, that we seek and get through open records law litigation, and make those available to the public. So when we started in 2016, we knew what our broad mission was, and we also then decided to focus on 3 particular areas, which are free speech and social media, transparency and democracy, and privacy and surveillance. And our goal in general, I would say, since I was there from the beginning, is one thing we wanted to do was distinguish ourselves from other organizations that are engaged in strategic litigation or advocacy work, public advocacy. So the big one would be the American Civil Liberties Union, which has been around for, I think it's over 100 years. And the ACLU had done a ton of work in the area of free speech and First Amendment work, but towards the end of the 20th century and in the beginning of the 21st century was focused more on other kinds of personal rights and a little bit less on First Amendment, although they certainly still do that. And we just wanted to carve out a role for us. So we didn't want to duplicate what other organizations were doing. And to some extent, we had a self-interest because we were trying to grow this organization and to get our name out there. But we also wanted to make sure, I think the strategic part of strategic litigation is you don't just take on a case because you think that what is happening is unjust or involves, government censorship or some other bad act, but you don't want to just make an impact in that one particular case, but to try to establish a body of law through, judicial precedents so that they can be used in other cases around the country, and to also develop an area of law. So, for example, if there are new questions about how should social media platform rights be treated, or content moderation be treated under existing law? Well, if no one's ever answered that question before, then you want to develop a sort of richer case law. So the first case that we took, which I really we brought it in 2017, so our first full year as an institute. And I will say that when I started at the institute, Trump had just been elected, and we had already been thinking about, what we were going to do and what kind of areas we wanted to pursue. And we recognized at the time that the Trump administration and Trump himself was going to pose some new, novel, and potentially upsetting, challenges to free speech. And so right away in the beginning of his first administration, we started hearing, this feels like, let's go back 10 years into the ancient history, but at the time it was unusual that he was using Twitter so much. They had never had a president who had used social media in the way that he did in the campaign to speak directly to the public. And there was some thought at the beginning, well, we don't know maybe he's going to become a serious person when he's actually serving, and he'll just use the official Twitter account of the presidency, which, Barack Obama had, which is at POTUS, President of the United States, or the at White House account. But as we all know, he didn't do that, and he continued using his personal account at Real Donald Trump while he was president. And, we were thinking, okay, well, what does that mean? And then we started seeing reports that he had been blocking individuals who responded to his tweets by criticizing him. And we saw this just by being on Twitter, which I had not really been on before then, and some people who had wanted to be part of the resistance. So they were very political, they were very upset about Trump, and so they would have an alarm on their phone anytime that he tweeted, so they could respond really quickly. And I think, although we don't really know how the algorithm works, but if you respond really quickly or you have a lot of followers, your comments are kind of at the top of the list under the comment threads. And so we just started seeing these people who would say, oh, look, I have a badge of honor, I've been blocked by Trump. And some of it seemed kind of funny, and also some of the people that he was blocking were celebrities, and Rosie O'Donnell and Chrissy Teigen, who's whatever, a food person, former model, and married to John Legend. And it felt like, something you'd sort of gossip about and sort of seem maybe frivolous. And we had this concern, like, is this something that's just silly that he's being kind of childish and blocking these people? But when we started thinking about it more, we actually thought there was a real problem, because he was obviously using his Twitter account as a huge source of his authority and power. And the idea, especially given our background of such strong protections for free speech, that a person could be blocked from his account simply because they criticized him. And these criticisms weren't, I think in the beginning people were like, well, were they threatening him? Or were these particularly vulgar or, off color? And they weren't. They were saying, you're terrible, you're corrupt, you didn't actually win the popular vote, things like that. And so we started contacting the people who had been blocked, and we put together a group of our plaintiffs of 7 individuals. And this is part of strategic litigation, is at the time we thought, okay, this issue had been litigated, the actual legal issue, in just one case, in a case brought by an individual who's proceeding pro se, meaning he was not a lawyer and he was representing himself. But other than that, there was no case that had addressed whether, when a government official uses a social media account, do they have any obligation under the First Amendment? Are they constrained from blocking someone? And so part of our strategy was, okay, let's find a bunch of people who are not celebrities, because we don't want it to just look like it's a celebrity fighting or something. And people that maybe represent, because you never know who your judge is going to be. And so you don't want it to seem, overly partisan or overly someone who's just seems like an off-putting plaintiff. I mean, honestly, in a lot of First Amendment cases, you often have, quote, off-putting plaintiffs. They're not the perfect plaintiff, but we wanted to have sort of a cross-section. So we had a police officer and veteran, we had a comedy writer, we had a sociology professor, and various other individuals. And we ended up filing our lawsuit in the summer of 2017. And we made the argument, going back to thinking about whether we were going to bring this case. It was our first major substantive case, and there was a lot of discussion in the Institute, is this a serious case? Is this something we want to spend our resources on? Does it really matter if someone's blocked from Twitter? And there were a lot of people, including some big law professors, who wrote articles saying, I think this is wrong, and there's no important value being served here. But as we started looking into it, we thought, okay, we know he's using this for such important, reasons. He is essentially using this as a megaphone to talk to the entire world, and you shouldn't be able to block people from that forum based on their viewpoints. And in making that argument, we drew on an existing doctrine called the public forum doctrine. And what that means is that's sort of grown up. It's sort of the classic idea is, if you have a city council meeting where members of the city council or the mayor or the government officials, they sit at the podium and they talk to the audience, members of the community come and sit in the audience, and they talk to the audience about their policies, what they're going to do, what they're going to spend the money on, whatever actions they're going to take. Then, if members of the audience have the ability and the right, which many times they do, to stand up and talk about and weigh in and say, well, I don't think you should spend the money on this, I think you should spend it on that, I think you're corrupt and I'm hoping to vote you out of office, but for now I want to say this, that, or the other thing, the Supreme Court has held that that is a public forum. And what that means is that a public forum is a physical space, or it can be as one Supreme Court justice said, a metaphysical space, but we're not going to, that could take hours to talk about, but it's a physical space that the government opens up to members of the public to come in and speak. And the court has held, when you have that kind of forum, you cannot kick someone out of that forum because they criticize the government or because you don't like what they have to say. And so our argument is, this is a digital public forum. Trump's Twitter account is a digital public forum. When he is tweeting, he is like standing at the podium, and he's the government official talking about his policies. And when everybody replies to him and puts comments in the comment threads, And then if you guys are social media users, respond to each other in the comment threads. That's like the audience talking to the official and with each other about political speech. And political speech is entitled to the highest level of First Amendment protection. So we filed our lawsuit, and the government basically came back, and their main argument was that this is not a public forum. It can't be a public forum for several reasons. One of them is that's his personal account. He has it at Real Donald Trump. He had it before he was president. He'll keep it after he's president, although we know he got kicked off of Twitter, but whatever. And so it's just a personal account. And the reason that matters is the First Amendment says that Congress shall make no law abridging, I'm paraphrasing, Congress shall make no law restricting speech or the rights of the press. And that has been interpreted to mean not just Congress, but any government official, but it only applies to the government. And so I can block whoever I want on social media, and any person who's a high-profile non-government employee can block whoever they want. But in this case, they argued, well, this is just his personal account, so the First Amendment doesn't apply, and that's called the state action doctrine. And then some people also said, you can't really have a public forum if it's on a private platform. That doesn't make any sense. That's not government property that you're opening up to speech. And so, our responses to that argument was, well, Twitter is a private platform, but when he has that account, he's engaged in government action when he blocks people from that account. And that's what matters, and that's what we're seeking to get access to, is for the rights of our plaintiffs to be able to respond to him and reply to him and talk with each other and other users. So anyway, we litigated the case, and as in many other cases that I think you can see currently, Trump keeps on providing, he does things that makes it easier for you as a litigant, because, he was saying, oh, this is a purely personal account, but then he kept on using it to make major policy announcements, to announce people that he was, firing or hiring as members of his cabinet, to engage in foreign policy, basically with the leaders of North Korea and other places. And we had all this other evidence, including the fact that his director of social media, who is his former golf caddy, he had access to the account. And so he even had government employees helping him run this account, is what we argue. I think the evidence was that he was doing all the tweets. Well, that's not true. The evidence was that sometimes people were writing his tweets for him, but that he was the only one doing the blocking. But, so we were getting into these sort of, who was blocking and what reason was it. But we ended up getting a great decision from the district court, and then we appealed, or the government appealed it to the Second Circuit Court of Appeals with 3-judge panel, and we won there. And then basically, our plaintiffs were reinstated. So we did send their, account handles to the government, and they unblocked it. And then we got a bunch of other people contacting us saying, well, I want to be unblocked too. And so we got a bunch of those people unblocked. However, they would never unblock Rosie O'Donnell, which I thought was interesting, and or Chrissy Teigen. But I guess they were, not bothered by that. So it was a great decision, and basically the Court of Appeals ultimately adopted our position that if a government official uses their account for official purposes, uses it to carry out their official duties, then they are engaged in state action. The First Amendment applies, and you can't block people based on them criticizing you. And the benefit of this decision is it started to lead to other court decisions from other circuits. U.S. has, actually, I don't know what it is, 12 federal appellate circuits, so they kind of decree the law in their geographic region, but we started getting other decisions. And I will say that the fact that we sued Trump got us a lot of attention in this case. I mean, anything involving Trump gets a ton of attention. And I think it was absolutely right on the merits for him. But we always believed that we wanted this principle to apply beyond Trump, that we wanted it to apply to, we saw that government officials at every level of both state and federal government all across the country were often using social media accounts as the primary way now to speak to and hear from their constituents, and they were often blocking people based on viewpoint. And the people who were blocking weren't just Republicans. On the day that the Second Circuit, meaning the Court of Appeals, ruled in our case against Trump, someone sued AOC, the sort of famously left-wing congresswoman, for blocking him from her Twitter account at AOC. And she ultimately unblocked him and conceded that it was not, she didn't really concede, but acknowledged by unblocking him that it was unlawful. In the actual Trump Twitter case, ultimately it ended up being dismissed as moot or vacated as moot, which was like a little bit frustrating, but what it meant is by the end, the government kept on appealing and appealed to the Supreme Court, and their request for appeal from the Supreme Court was pending when Biden assumed office. So there's this doctrine that says, if a case hasn't ended by the time something becomes moot, then it no longer is a binding precedent. And so, which matters for trying to establish the law. So that was like a little frustrating because he was able to have that case be considered vacated. But the principle has, lived on, as I like to think. And actually by now, the Supreme Court has never directly answered this question, which again was very novel in 2016, 2017. Is a government-run social media account a public forum? But in a kind of adjacent case just last year, the court seemed to acknowledge that if you are using a social media account, you're a government official, and you're using it to carry out your official duties, and you're authorized to speak on behalf of the government, then you do have to follow the First Amendment and you can't block critics. So from the perspective of, is this a good use of our resources? Like that felt like a really good, example of this kind of strategic litigation. And we continue to do it. We're actually now that's over. We had another case, where, for instance, an agency, a lot of these cases involved individual officials who are, tweeting from their, quote, personal accounts. But we have another case where the National Institutes of Health, which I don't know, at this point, maybe it's no longer in existence, but let's assume it is. They have their own Twitter account and Instagram account. And we found out that they were, a lot of social media accounts, sites will let you keyword block. So you can say, I don't want any of the following words to appear in any comment in response to our posts. And so although the NIH didn't tell anyone, it turns out that they had made all these keyword blocking that were like, they wanted to block animal rights activists from posting in response to their commenting in response to their posts. So they blocked words like animal testing, cruelty, monkey, PETA, people for ethical treatment of animals, and other, basically any words that animal rights activists were likely to use. So we sued them on behalf of PETA and another animal rights organization, and ultimately got a very good decision that said you can't, because what they were using is they were just using an automated keyword blocking program, which they claimed was, well, we don't want any off-topic comments. Our forum is limited. You can't say anything you want. It has to be on topic and related to the post. And our reaction was, okay, well, even assuming that that is your policy, and there were some questions because they hadn't done that for any other topics. No, they had taken no other efforts to try to keep comments on topic, but it doesn't make any sense to say, I know that in perpetuity, stop animal testing will never be relevant, because the NIH often posts things related to animal testing, and so we got a good decision from the DC Court of Appeals saying that is an unreasonable and essentially irrational approach. So I like to think that Trump Twitter lives on, even though it's not actually in effect. So then the other sort of big case from the first Trump administration involves a challenge to a policy that was implemented in Trump in his first administration by the State Department that says anyone that's applying to enter the U.S. for applying for a visa has to provide the government with your social media handles going back for 5 years that you've used on 8 social media platforms going back for 5 years. And this was, again, a very novel, this sort of idea of the government kind of requiring you to register your social media activity is new. And what it means under the First Amendment is not clear. But we thought it seemed bad, that the idea that the government is going to basically get all this information from you and keep it under the terms of the policy forever, and possibly share it with Department of Homeland Security or maybe even other countries, and that it posed real problems and threats to First Amendment freedoms. And our sort of big arguments were, one, there's a very strong recognition about the right to engage in anonymous speech. So going back into like the founding of the U.S. Constitution, a lot of the founding fathers actually published under anonymous names. And there's, of course, a huge tradition of publishing anonymously. You can have arguments about whether it's good to be anonymous or not, but it certainly allows people to engage in pointed political speech without fear, or hopefully without fear of retribution. And if you're required to give your social media handle, so if you are a person who lives overseas in an authoritarian country and you've been publishing, you've been tweeting under a handle that's anonymous, and you have to give it to the U.S. government in order to get a visa to come into the U.S., and it's possible that the U.S. may share that with that government, that's obviously presents a real chilling effect on your right to engage in speech. It means that you're not going to be able to engage in anonymous speech, arguably. And so we wanted to bring that case to challenge that, and also the sort of broader idea that the government isn't justified in this huge, generalized kind of dragnet approach to gathering up any, millions of people every year that are applying for visas, where then they can scrutinize their social media activity, and that will chill their speech and chill their ability to associate. Maybe if you see, you've posted on this one site, and they'll start thinking, you must support a terrorist organization, but you don't, and so we wanted to challenge it. But the challenge to us challenging it, I could probably come up with better words, but is that people who are applying for visas living overseas don't have recognized First Amendment rights. And so we brought a case under the first Trump administration where we argued that the fact that people who are applying for visas, their speech is going to be chilled, affects people who live in the U.S. who want to hear from them. And a kind of obvious thing would be, I'll just use our actual plaintiffs. Our plaintiffs were documentary film organizations that have a lot of either overseas partners, or members. And so they often engage in film festivals and just like an exchange of ideas and films with people overseas, including people who live in, oppressive regimes, et cetera. And so what they argued is, we have a right to hear from our partners who live overseas. And, our argument is that the right to speak under the First Amendment, the flip side of the coin is the right to hear. And so, and the Supreme Court has recognized that, and in particular in the case of someone whose visa was revoked, who was going to come and speak to some people in the U.S., and this was in the era of, fear of communism, and so he was denied this visa, and the people in the U.S. said, well, we want to hear from him. And so we have made that argument in this case, that our rights as documentary film organizations are affected because these people are going to stop posting on social media because they don't want to hand their identities over to the State Department, and that means we're not going to get access to that speech. But we have it's taken a long time, and no one has actually even really delved into the merits of that question, because one major obstacle to strategic litigation for First Amendment rights, well, any kind of rights in the U.S., is you can't just say, I think what the government is doing here violates the First Amendment. And, anyone could go in and just say, I'm filing a claim, this violates the First Amendment. Because that would be really easy, and we'd have, much better luck, you know, but you have to show that it actually affects you in a concrete and redressable way. So you have to show that, like, I actually was going to speak, you know, and and my speech really has been chilled, and I, as the listener, was going to listen to it. And it's not just general listen. It, like, I know this one filmmaker who stopped posting on Twitter because he was worried about handing his information over to the U.S. So the case has been litigated for a long time. It's still going on. We lost on standing in the trial court, and I'm just trying to think what we appealed the case to the D.C. Circuit, which is the appellate court in D.C., and that was argued last winter, and we're waiting for the decision. And, you know, I think we're probably not going to succeed in that case. And we were talking earlier today about, if you're thinking about strategic litigation, like, how do you measure success? And it's broader than just winning, I will say, or we have to think that, given in part our mission. And for me, it's been very interesting, having been in private practice for so long, where you're just thinking, like, are we going to win this case or not? If you win it, it's great. If you lose it, it's terrible. But here, we often are making broader arguments than maybe have been accepted or will be accepted under current law. But we see a value of bringing these lawsuits for a number of reasons. One, public education and getting the word out there. I mean, I think a lot of people don't, if you've applied for a visa, I mean, I don't think Canadians have to apply for a visa, but good point. Yeah, any moment now. But, so to get the word out, but also the fact that sort of, if you see government action increasingly taking this approach of, we want everybody's social media handles, and now we're going to use AI to be able to look through it more, efficiently. Because in the beginning it was like, well, could they really look at millions of people's social media handles? Probably not. But if you can do it really quickly and say, I want to flag any mention of Hamas, even if what you've posted is Hamas is terrible, that's, creates a real concern of the government's availability to essentially, surveil what you're writing, who you're talking to, what your interests are. And we think that really invades on free speech and the ability to speak freely. And under the second Trump administration, they have proposed rules that would apply this same social media registration requirement to other people who are applying for other kinds of visas, including people who are applying to become citizens, for green cards, and for other kinds of visas. So that kind of changes the legal calculus somewhat, because, as I was saying, people who are living overseas and just applying for a tourist visa or some kind of short-term visa, they don't have recognized First Amendment rights. But people who live in the U.S., even if they're not citizens, are recognized to have First Amendment rights and due process rights. I mean, hopefully, if they're enforced by the courts. But so if the new Trump administration adopts those rules, I mean, to some extent, it'll determine whether or not how this D.C. Circuit rules on our current case, but it helps lay the groundwork for making this argument that you should be able to review it. There should be judicial review of this kind of action, and to stop the government from doing such a sort of generalized. In the case, we sort of conceded, yes, the government in any individual circumstance could look at someone's social media postings, like if you had some reason to think, oh, this person maybe pose a threat, we sort of had to concede because we thought that the courts would absolutely believe that you should be allowed to do that. But our argument is there's a difference between individual looking at and just requiring everybody to kind of provide all of their social media handles. Okay, so that's sort of the background and the normal. Oh, sorry, in that case, also, I should say, persisted through the Biden administration, because it was introduced in Trump 1. The Biden administration came in. Biden said he was going to reconsider a lot of the, immigration rules under Trump. So we put our case on hold for about a year. Government grinds slowly often. But then Biden decided he was going to continue to have this policy, and so we continued litigating it. I'm trying to think under the Biden administration, we certainly still had lawsuits. Some of our lawsuits, but they, Biden just didn't take the kind of actions that you are seeing under the, I don't mean to say that that Democratic-run governments don't take actions that violate the First Amendment. They definitely do. But nothing really particularly stood out. And so, but we did other kinds of cases involving some private actors, actually, not just government actors. So anyway, this brings me to Trump 2.0 or too fast, too furious. And I would say that it is fair to say that the Trump administration's first 100 days have brought an unprecedented assault on free speech and the rights of the press. I have been litigating First Amendment cases for 25 years, and I've never seen anything like this. And, I'm not someone who's prone to extreme statements like that, but it really has been remarkable, and that they just, I think, pose a grave danger to First Amendment freedoms. Excuse me. I think the biggest example of that, although it's hard, there's competition for what's the worst, but I think the big one that comes to mind is using immigration laws to deport people, students primarily, based purely on speech. That has been sort of a bedrock, principle, is that you don't take restrictive government action based only on speech as opposed to conduct. And the Trump administration obviously has been just arresting, detaining, and transferring these students, or some of whom have graduated. Some of whom have student visas, and the government has a lot more leeway to revoke a student visa, but I would still argue that they can't do it based purely on protected speech. But green card holders have even more, rights, and the idea that you could deport someone who has a green card who's lived in the United States. One of the students being targeted, Yunseo Chung, is a Columbia undergrad who is currently in hiding. She, I believe, I don't know if she's Columbia or Barnard, but she was at a pro-Palestinian protest, and she was arrested and given something called a desk ticket, but there was no indication that she engaged in any violence, and she was just at a protest. And she's lived in the United States. I think she's 21 now. She's lived there since she was 7. She has a green card. She saw everything that was happening. ICE, with a warrant, came to search her dorm under the idea that the dorm, they claimed an authority to search a dorm for harboring an illegal alien, but she's not illegal, and I think the warrant was probably unlawfully obtained. It's just, though each step of this is just, mind-blown, terrible violations of civil liberties and civil rights, but it's based purely on her speech. And then you have Mahmoud Khalil, who was, arrested in front of his 8-month pregnant wife, and he was a leader of the pro-Palestinian protesters at Columbia, but there's no indication that he ever broke any law, and in fact, he often played the role as a sort of negotiator with the protesters. And I see people nodding, I'm sure you're aware of this, but basically ICE arrested him, but took him to Louisiana. And, if you've seen some of the news reports, a lot of these people, including Ozturk from the Tufts PhD student, and what's his name? Madawi, that one. Anyway, this person, Madawi, who's like a Buddhist, and by all accounts he was a Columbia graduate living in Vermont, and they told him he was going to have a citizenship interview, and he went to the he thought this might be a trap. It was a trap. He went through the test and was going to take the oath, and then they arrested him, tried to send him to Louisiana. The reason why they're trying to send all of these people to Louisiana is because it is an extremely conservative judicial circuit. And so the idea is the theory that the Trump administration clearly thinks they will do much better with the judges in that circuit as opposed to the judges in New England. Oh, okay. Oh, it's been a long time. Sorry. Okay. New England or New York. But it just seems horrible. And so I think this is just such a, obviously the personal stories are very compelling and terrible. And, this Madawi person was a Columbia graduate. He reached across and made friends with a lot of Israeli students. And, anyway, it just seems like it's just absolutely not the kinds of thing that we would see in a country that valued free speech and protecting speech. And there's no limit to the government's theory, because this has been focused on, the Trump administration is claiming it's a way to combat anti-Semitism. But what if next it could be for criticizing President Trump, or criticizing their immigration policy, or any there's just no limit to it at all, and there's no limit under existing First Amendment principles that they're going to claim that it's supporting terrorism, but again, the facts don't bear that out. But the other thing is it's really worrisome about how these claims, these free speech claims in these contexts are going to be litigated. So each of these individual students are making these arguments that it violates the First Amendment for them to be subject to deportation based on their speech. But because of the immigration laws, none of these cases, as far as I know, have got to an actual airing of that specific arguments. It's all about jurisdiction. Should they be in Louisiana or Vermont or New York or New Jersey? And then just the fact that this is happening is creating a huge chilling effect on speech. And, we often in First Amendment law talk about chilling effect. And sometimes it's sort of in the abstract. Well, if I think I could be, punished for writing this, I might not write this. But I just feel like we hear every day about actual, real chilling effects. People I know personally who are going back through all of their social media postings and taking out anything that might be seen as critical of Israel or pro-Palestinian or in any way politically charged. And, student newspapers, college newspapers are reporting that a lot of students who have written, about students who have visas or aren't citizens, asking for their names to be taken down from articles they've written because if you look at Ozturk and, not wanting to participate in conferences. There's like a real tangible chilling effect. So what we have done is we have challenged the policy, we call it the ideological deportation policy, and about a month ago, maybe a little longer, we filed a lawsuit on behalf of the American Association of University Professors, some of its specific, like the Harvard chapter of AAUP, and a Middle Eastern Studies Association of students and professors. And we brought a lawsuit in Boston challenging it as violating the First Amendment, that this policy, which is sort of reflected in some of the executive orders and certainly in all of the many statements by the administration, violates the First Amendment to deport students based, and we've said specifically on pro-Palestinian or anti-Israel speech. So we actually just today, the government moved to dismiss this case. And in that case, once again, talking about like the visa social media collection, we didn't have the actual students that were being deported or were subject to deportation as our plaintiffs for understandable reasons. If you haven't been deported yet, you don't want to go out and put your name on a complaint. And so we brought it on behalf of associations. And there is a recognized doctrine in the law that says if you have an association and the members are affected by a particular policy, you can challenge it as an association. And of course, we're making the argument that we need to, in our complaint, we said, this member had this happen, this member had that happen, this member took down their social media postings, et cetera, but we said they're anonymous for obvious reasons because of fear of retribution or being deported. And there was a hearing last week, and the judge was kind of skeptical about this standing argument. It turns out a lot of these cases really do kind of rise and fall on the standing arguments, which seems boring. Honestly, when I started working at the Knight Institute, I was like, oh, standing, that's so boring. But a lot of it, rises and falls because whether you're going to get your day in court and be able to make this, claim. And so the judge there was pretty skeptical and he didn't seem very favorably disposed to us in the hearing, but lo and behold, we got a decision today, 6 days later. He's an 85-year-old judge, very sharp, and wrote a 68-page opinion denying the government's motion to dismiss this case for lack of standing. Now, there's still some hurdles to come, but it was good because at the beginning of the decision, it was the First Amendment means that everybody can speak their mind and criticize the government. Whenever you read a court opinion that starts with that, you're okay, good. I think this is going to go well for us, at least as for now. So then the other sort of major case that we've worked on in the Trump, well, there's a bunch, but involves, and again, everybody's sort of nodding, so I'm assuming, but this is switching gears to press freedoms, but the White House's decision to revoke the Associated Press's access to the White House press pool. And I honestly call this case, Make America Stupid Again, because it is so dumb. The idea that, one of his first executive orders was that Trump decreed that the Gulf of Mexico shall now be known as the Gulf of America. And a lot of companies and press outlets followed suit. You followed what the government said. There was also a Mount McKinley in Alaska, had been renamed under Biden and switched back. But the AP said, well, we're going to still call it the Gulf of Mexico because that's what it's been called for 600 years or something like that. And we have an international audience. It shares borders with, it's not just based, like Mount McKinley, it's not just based within the U.S.'s own borders. And so we're going to call it Gulf of Mexico, comma, which the Trump administration has changed to Gulf of America, which to me sounds perfectly acceptable, but not to Donald Trump in the White House. And so they basically started saying, AP, you can't come into the White House press pool. And what the press pool is, there's, the White House reporters all can get badges that allow them to go into the White House. But then there are these smaller press pool, which is basically areas where all of the White House press corps couldn't fit in because they're small, like the Oval Office or going on trips with the president on Air Force One. But for decades, the White House has a system where it allows kind of representatives of each kind of media, broadcast, wire services, print, where they'll basically say, okay, you're going to go on this one trip. The president's traveling to this one place. You're going to go there. He's having a meeting in the Oval Office, and we're opening up to the press. But he said no longer can the AP be part of that unless you change it back to, unless you start calling it Gulf of America. And so the AP filed a lawsuit challenging it and argued that it violated their First Amendment right. It was basically a retaliatory action. And the First Amendment does recognize that if the government punishes you in some way because of your speech, that violates the First Amendment. But it also raised this question of the public forum doctrine, again, our friend that we talked about earlier, where the argument being that because the White House for decades had said, yeah, you can come into the Oval Office and we're going to allow, let's say 10 members of the, reporters to come in, that's a public forum. And it may be a limited public forum. It's only limited to 10 people, and there may be a lot of rules around it. You can't come in any time. You can't just open the door. You can only come in when you're invited. But the meaning of the public forum doctrine is even in places called a limited public forum, you can't say, well, you reporter can't come in because I don't like you, because you criticize me, or because I don't like what you write about me, or how you write, or whether you say Gulf of Mexico. And so the district court in that case had a bunch of, asked for a bunch of briefs, and we submitted a brief in that case making this public forum argument, which the AP had not made itself. And as I was telling you earlier, we felt like vindicated or whatever, just we thought it was good because when the district court did rule that it did violate the First Amendment for the White House to do this, it used the public forum doctrine and accepted our argument and didn't focus as much on the retaliation, although that was in there as well. The one thing about the public forum doctrine is it's not always a perfect solution, because one thing is you can always change a forum and you can even shut it down. Because I think the big issue in this case is it seems wrong that you shouldn't allow the AP in because they won't use the language you like. That seems bad. And I think one of the things that the arguments we made in our briefs is that our concern is it's like if you look at reports about Putin when he started like really consolidating control, he used to have press access in the Kremlin where different people would ask him questions, kind of like a press pool. And then he started kicking certain reporters out because they were more critical. And now he just has people in who fawn over him and just say, you're great, and ask questions that are just supporting the government. And our view is that is not what a vigorous press is supposed to do. And that's not what is good for democracy, to have people just, parrot and praise what the government is doing. On the other hand, other people can argue, well, it's his office, and why should he have to invite everybody in? And certainly, doctrinally, it's a little confusing because, yes, there's a public forum, but he would be within his rights to say, I'm just inviting Fox in for an exclusive interview. There's nothing wrong with that. And so how do you draw the line? When is it more like an exclusive interview, and when is it more like you're really opening it on like a fair basis? So that remains to be seen, but also what has happened since this case started is that the White House has started changing its rules. And so even while this lawsuit was happening, the day after the lawsuit was filed, the White House said, it used to be that there's an organization called the White House Correspondents Association, and they were the ones that would select each individual journalist who would go into the press pool. And then they said, oh, no, it's no longer going to be the White House Correspondents Association that's doing that. Levitt is going to, is it Carolyn Levitt? Whatever. Yeah, Carolyn Levitt or the White House is going to make that decision. And then they started saying, okay, well, we don't want to allow only wire reporters always having a seat there. We want to open it up to more new media. And so now they've really, and to some extent, as a First Amendment person, I'm like, well, that's good. You shouldn't just give it to like certain gatekeepers that are historically, favored. On the other hand, I think if you watch some of the recent press conferences, you will see these people from, like this guy, Tim Pool. I'm not even sure who he is. I do know who he is, but he's someone who is, I guess he's a journalist, but he was found to have been given like hundreds of thousands of dollars or millions of dollars by Russia to fund his podcasts and his writing. So, that's who now is covering the White House. So, that may be kind of a limited victory on the White House press corps. And I think it's terrible. I think you won't be able to trust the reporting coming out if you're not going to allow people on a non-viewpoint discriminatory way to cover the White House. So those are two of the bad things. Then we also have, as of course everybody knows, the targeting of law firms, which we haven't taken. We've signed on to briefs, amicus briefs in those cases, friend of the court briefs, along with the ACLU and other civil rights organizations. But I think it's a real dangerous thing for the rule of law, not just for those individual law firms, because it's bad to be threatened by the government based on the cases that you bring. But for the public interest, a lot of law firms in the states have traditionally provided pro bono legal work for free, including a lot of cases that are challenging government actions. And organizations like mine rely on those partnerships with law firms to help us litigate these cases. And, if you see some of these law firms folding and agreeing to, first of all, basically cutting deals with the White House, which the White House is describing as giving them essentially in-kind donations, which, is just crazy because they're basically saying, we will dedicate $125 million of pro bono work over the next 4 years to the White House. I've never seen anything like that. But also that presumably none of those firms are going to take any case that challenges the Trump administration because they don't want to get back into the crosshairs from him. I will just say that my former law firm was targeted by this executive order, and they fought back, which is yay. And it was purely based on that they employed someone who Trump hates, and he's not even there anymore. I mean, it's just, and these orders are just so illegal in so many ways. It's like if you were to teach constitutional law, this would be a great exam, an issue spotting exam of like how many ways does this violate the Constitution. But it's really frightening that all these firms, and you see this in other ways, like my own university, folding in advance, even when threatened with clearly unlawful action and not fighting back. It hurts not just them, I think, but it hurts, the broader society. And so then we come to the university issue. And again, what is so unprecedented about this is the government, particularly Republicans. Republicans have generally been like, or conservatives, whatever, private entities are sacrosanct. Private industry should be able to do whatever it wants, and the First Amendment only binds the government. It doesn't bind. Private corporations can say whatever they want. They can spend their money however they want. They can use their money for political contributions however they want. But then to have the government actually going in and saying, we don't like if the cases you take or the courses that you teach or how you describe certain things like, DEI, and to use this huge threat of the millions and millions and millions and billions of dollars of government money and other kinds of threats like revoking your tax status or, anyway, a huge number of threats because we don't like how you speak or how you associate or the positions you take. And that is just so dangerous to free speech. And, I am at Columbia University. I was very, disappointed that they didn't push back at all. It's still ongoing. I don't know what's going to happen. I mean, basically, the Trump administration said, we're going to revoke $400 million from you. And here are preconditions for even negotiating about that $400 million. And Columbia did those preconditions without ever saying, well, do you think it's bad that the government's coming after us? And now they still don't have the $400 million back. Now, I'll see what happens because, of course, then Harvard looked like it was going down the same road. And then, as you may have all read, the Trump administration accidentally sent an email with a list of outrageous demands that I think essentially made Harvard realize it could not agree to those. It was an existential threat to Harvard. I mean, they're also facing, or the universities are facing financial existential threats, but a sort of principal existential threats. And so they forced, I believe, Harvard to take a stand and fight back. And I am heartened by more universities sort of coming together and supporting each other to try to fight back. People talk about collective action. I think that would be helpful too. So I don't know what will happen with Columbia. And these are just my own personal views, I should say. But, because I'm not speaking on behalf of Columbia. But, so, yeah, that's sort of where we're at. So I think we are...
Good conference.
Of course. Where should I?
I guess that you should stay here.
Okay.
Alors, si vous avez des questions pour la conférencière, encore une fois, vous allez poser en anglais, en français, il n'y a pas de souci. Si c'est en français, je vais simplement traduire questions et réponses.
Yes. There's a huge debate among law professors and lawyers and journalists about, is it a constitutional crisis? I guess my response is, I think to some extent when people are talking about constitutional crisis in particular, they're talking about the separation of powers and the question of, will the Trump administration follow or obey the court's rulings? And this has been a huge part of our system since 1807 or whatever it was, Marbury versus Madison, these cases from the Supreme Court in the very early part of our country where they said, okay, the executive has the power to do this, Congress passes legislation, and the courts interpret the law, and they can say whether, I don't know if they said this in Marbury versus Madison, so don't hold me to this, but if the executive or the Congress does something that violates the law and the courts say it violates the law, our whole system, like, the only reason our system can persist is assuming that the executive is going to follow it. Okay? So you say that you violated the First Amendment, so then you have to, and the court issues an injunction or a declaration says this is unconstitutional, and the executive has to comply. And so I think one of the big questions that people have been really talking about is, when they deported this Maryland man to El Salvador, and then they said in court, this was a mistake. We shouldn't have deported him. And then, it goes up and the Supreme Court, the district court says, oh, you have to facilitate or effectuate his return. And then the Supreme Court says, well, not effectuate. And, although that was frustrating, I actually can understand the idea because in theory, if it was a different country, North Korea, you probably can't effectuate a return of someone from North Korea, because if they say, well, we're not going to do it, there's only some limited power. However, what the Supreme Court said is, I'm sympathetic to that argument in principle, but here, obviously, the U.S. sent these people to El Salvador under some kind of mysterious arrangement where the U.S. is paying El Salvador to hold them. So I don't think it's like someone going to North Korea. So I'll just say that at the outset. But I think the bigger concern was the Supreme Court said, well, you have to at least facilitate returns, take some, action. And then the Trump administration basically just dug in and seemed to be ignoring the lower court orders of saying, please tell me what you're doing to facilitate his return. And so that's been a very thing that's made people feel really worried, that if they basically say, we're not going to follow what the Supreme Court says, that's our whole constitutional system, separation of powers and rule of law, and they all have to buy into that. In terms of other crises, because I think other people will say, well, it's a constitutional crisis to deport people without any due process, to say that you're going to send citizens. He's basically suggested that we would send prisoners that are held in the U.S. to El Salvador, and they want to do it without due process. I think that is a huge problem, and I think if the whole populace doesn't agree with that, then yes, we could just go towards authoritarianism and not. I mean, we're already going towards it, but we could go further towards it. I do think public opinion, at least as reflected in recent polls, is changing, and that it at least is reflecting a majority of people don't want that to happen, and are concerned. They sort of want immigration laws enforced. If you say, should we deport illegal immigrants? People are like, yes. But if you're like, well, should we deport them without any protection and without determining if they're actually the right person to deport, then people say, well, no, actually, I don't want to do it that way. So, but yes, I think we're at a really dangerous place. Yeah, that's a great question. Okay, there's a lot of answers I have to that. So first of all, under current, long-held Supreme Court precedent, hate speech is actually fully protected under the First Amendment. You can say the absolute worst racial slurs and hateful speech, and particularly in contrast to Germany, you could say terrible things and false things about the Holocaust, and that's protected by the First Amendment. And that part of the First Amendment, I think a lot of people don't really like. I think I often talk about it, the First Amendment, people are like, oh, that's great, we want citizens and democracy, et cetera. But the fact that it protects even just abhorrent speech and speech that really is hurtful, is upsetting to some people. On the other hand, the argument is, well, we don't want the government making the decision about what speech is allowed or not allowed because, at some point that could be used against you. And that there is something, I think, valuable or lofty in the idea of that we have such strong protections for speech that we can protect even like really strong and upsetting speech, and that means that we just protect all speech. It's pretty rich in my mind, and meaning by rich I'm meaning hypocritical, that Vance is going over to Europe and saying, well, we don't want you to ban hate speech. And I'm not exactly, I think that's about kind of the brosphere or whatever you call it, about, that right-wing influencers maybe are having their speech censored in Germany. I actually don't really know exactly, but I think it's like, it has to do with sort of protection of speech, the difference of European rules about speech and how they apply to social media platforms as opposed to in the U.S. So in the U.S., the government could not ban hate speech on social media platforms. However, the platforms themselves generally do. But the hypocrisy for Vance is that he's claiming this free speech mantle, but then his administration is actually using actual government power to actually censor speech. So, a lot of the people on the right, including Vance and others during the Biden administration, were saying, oh, everybody's so biased against conservative voices, and the platforms are kicking off, conservative voices. And so they were saying, I think one of the things that Trump, one of the first things he said, one of his first executive orders is like, this is the free speech administration. And then they've, proceeded to do all these very anti-free speech things. There was another point I was going to make about, and then I believe, I don't know if this is confirmed, but when Musk took over Twitter, now X, I think he wanted to say, oh yeah, I'll allow people on who espouse Nazism or have been kicked off for engaging in hate speech or disinformation. But I thought that he made it so you couldn't sort of accuse people of being anti-trans or something like that. So anyway, he had a new hate speech was, I can't remember what it was, but it was just political, basically, so. Right. Yeah. So, so first of all, there are some, the First Amendment is interpreted so broadly to protect so much speech. There are some exceptions, something called true threats. So you can ban a true threat. So the government could come and say, if you really, but a true threat has to be a very direct and kind of concrete, like, I'm going to come to your house and kill you in 10 minutes or something like that. It can't just be like, I hope you die someday. So it's a little hard, but if you really if you made a truly threatening comment to someone, then the government could ban that. Also, actually threatening the president is unlawful. And some people have been arrested under any administration for that. But we did think about this when we were bringing the Trump Twitter case, because we were like, okay, well, Trump, first of all, he's always threatening and saying, like, offensive things to other people. So he's not, but what about AOC? What about people who are subject to harassment that's misogynistic or racist or, anti-Semitic, which is a lot of it. Do we want those officials to have to put up with it? I think ultimately we came out on the side of, if it's not a true threat, then you should just allow the speech to be out there. And, there might be some steps you could take to try, if someone was really targeting you, to say, okay, in this forum, I have a rule that you can only comment, X number of times a day, or, and because the courts have recognized you can make these viewpoint neutral time, place, and manner restrictions in a forum. So as a way to kind of get at kind of bad behavior, but without targeting speech. And then sometimes, the argument could be, well, like for Twitter specifically, not necessarily other platforms, you can mute people. No, the other platforms have that too. So the idea would be, okay, if you really didn't want to see it, but muting at least would be a way of protecting yourself from harassment, but without censoring that person or making or excluding that person from the forum. But that's kind of the hardest issue. But I will say that when AOC was sued for blocking someone, her first reaction was, I get harassed all the time on my account, and I shouldn't have to give a platform to people who are saying these horrible things to me. And in theory, that resonates with me. But the person she had blocked had just criticized completely political speech. Like, she had compared the migrant shelters with children, the family shelters, to concentration camps. And this person had said, that's not, that's a wrong, criticized her for making that comparison. That's just pure, that's not, hate speech or slurs or anything like that. So most of the time when people block people, maybe when officials block people, it doesn't really hold up in terms of the actual, they just don't like being criticized. Another great question. So it's actually a slightly different doctrine. So there's true threats, but then there's something called incitement. And this was an issue that the Supreme Court, I know I just keep on talking about the Supreme Court, but obviously they're the boss of me. No, they declare what the law is, but that the Supreme Court struggled with in the 20th century, where basically it's called incitement speech. So if you get up there, and what the court ended up ruling in the late 1960s, I believe, in a case involving the KKK in Indiana, where a guy had gone up there and exhorted his followers to, let's go to Washington, D.C. and engage in lawlessness. And he was prosecuted under a state law that said, if you incite others to violence, then you can be punished for your speech, even if it's just speech. Because, there's this whole thing of we don't ever want to punish speech. But then the court said, okay, that has to be much narrower, because we actually want people to be able to advocate for violent overthrow of the government, because sometimes people think, okay, well, that's a way to pursue, our rights, or to vindicate certain principles. But if you're saying it in a more abstract way, they say, well, that's protected. So basically, this is the Brandenburg case. So it says you can only punish speech if you intend to incite immediate or imminent violence or unlawfulness, and if it's likely that will occur. And so there was this huge discussion of what Trump did. And honestly, before I was at the Knight Institute, I worked in a lot of cases involving violent video games that I wanted to protect as speech. So anyway, but that's another thing. But sometimes they would say, oh, this is like incitement. These video games are inciting people to act violently. And we would always say, no, incitement is very narrow. You have to intend it. You have to... it has to be immediate, like close in time, and it has to be likely to occur. And so I was always like, there's not very much that would qualify incitement. And then you see Trump, and you're like, well, that's pretty close. But I think ultimately, Biden administration, was charging him related to his actions on January 6th, but they did not charge him for incitement. I'm pretty sure, because I think they thought that although there were all those links, that his language was sufficiently loose, which often he uses loose language, that it wasn't like, he did say, I want my supporters to go to the Capitol, but basically he didn't say, go to the Capitol and break in. So I think that the prosecutors just thought we might not win on that case. And even if we won before a jury, it's possible that the court would overturn it as being too broad of a, But I don't know. This came pretty darn close, if not over the line. That's a whole other nightmare that I haven't gotten into as much. Meaning I haven't studied that case as much. It's very troubling, and certainly I can't remember exactly. Everything sort of blends into each other. But I think there was an argument about when he was acting to overturn the election results, was he acting in his personal capacity or in his official capacity? And I think the Supreme Court's decision is really bad, because it basically seemed to interpret official capacity really broadly, such that, he could say, because you'd say, well, he was just actually trying to protect his own personal interests as a candidate, rather than as president. But yeah, I think a lot of that, I was just thinking we used to always say, like, what if he murdered someone, and then it was like, well, ha, 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 that won't happen. I think there was a movie about this. But anyway, I don't know. I think it's deeply concerning, as we'll say. Thank you. I'm definitely not a historian, so I don't want to say it with absolute certitude, but I don't think there is a clear precedent historically. I think the closest is Nixon, and he got very close to where he didn't want to turn over certain materials, and a court was ordering him to do it, and he fought it all the way to the Supreme Court. And although they did recognize that he would have some protection for having to produce some things, they did say that he was subject to the subpoena, and he did comply with it. I think the big mechanism, but I think that was close to being. I mean, I think Watergate is the closest analogy as to Trump, and then as to some of the other stuff he's doing, the closest analogy is the Red Scare and McCarthyism against communists. But with Nixon, then it was impeachment. I mean, the mechanism is impeachment. But we have this, there is a mechanism that you basically can be tried for high crimes and misdemeanors. And obviously he's been impeached twice, but not convicted. And that's the problem, is that you need, I can't remember if it's 2/3, I should know this, but you need not 2/3, whatever, of the Senate to convict him. And we're just so deadlocked with our partisanship that I just don't know that. I mean, it did happen. Well, they were going to do it, and then he resigned with Nixon. But that's the problem. And that's also this impeachment. It is hard because the impeachment mechanism is really built in there, but the reality is it's not going to work. And so a lot of times when the Supreme Court is granting immunity or giving a lot of leeway to the executive branch, they're saying, well, that's okay because there's this mechanism of impeachment. And again, in theory, under democracy, you think, okay, well, that's right. If it's bad enough, everybody will get together and impeach him. But I don't know. We seem really stuck. Yes, and I will say, I don't know whether it matters, at least thus far, when pressed, Trump says, I'll obey the Supreme Court. So, we'll see how far he wants to go. And not just him, how far his supporters will go, obviously. But yes, I am worried for the Knight Institute. I mean, meaning not specifically us, but for a lot of nonprofits. And I do think, I haven't read Project 2025, which I gather is 925 pages. So there's got to be like a condensed version somewhere. But I think one of the steps is, it's very clearly go after universities, go after, I don't know if the law firms were a thing, but yeah, go after big nonprofits. And I did hear I saw some sort of concern that they were going to try to, or indication that they were maybe going to target some of the big left-leaning foundations and do that through, and again, it's a trying to impose their own viewpoints and restrict the speech or restrict the use of money to further the causes, on their own agenda on private entities. And that is such a violation of existing norms. But I do know that a lot of nonprofits and nonprofit news organizations are very worried about either the IRS or the Treasury Department or both using their powers to try to either revoke the nonprofit, the tax exempt status of nonprofits, which is huge if you're going to operate as a nonprofit, or penalize them in some way. That's the big one. I'm forgetting there's some mechanism of law like endorse or espouse terrorism. Anyway, there's some existing law that you could start arguing to say, okay, if you cover I mean, obviously the Israeli-Gaza conflict is the big one, but if you cover that in a way that's sympathetic to, or can be argued that it's sympathetic to Hamas, then you have endorsed or espoused a terrorist organization, and we can impose all these sanctions on you or take away your nonprofit status or whatever. And then, yes, I mean, we're part of the Columbia community, and the Columbia University, I mean, again, I'm critical that they didn't stand up to it, but of course, it's a huge threat to their finances, and not just the $400 million, which is already a stunning amount of money, but future and more other one. I mean, I think, I know some university, I don't know, it's Harvard, was like $9 billion in grants or something like that. So, we're a funded, independently funded institute, but we're part of the university, and I think this could be, and you're already seeing cuts to a lot of universities and labs because of these threats. So I think everybody should be worried. Well, unless you're Fox News. I don't think they're worried. I think they're okay, as long as they don't criticize, yeah.
There's a lot of things that are in Project 2025, but Let's Go After Canada wasn't part of it.
Yes, that seems to be a pet project. Trump, yeah. That one is really...
For us as well.
Yes, I'm sure.
That's okay. I was kind of wondering about you have at the Knight Institute a branch dedicated to public education.
Yes.
And one of the problems I see is as well about we're getting near a constitutional crisis, but you've avoided. The Trump 2 administration is relying on savage interpretation of some rulings. And the worst case for my part was the Stephen Miller interpretation of the ruling concerning related to Kilmar Obregow-Garcia, that the Supreme Court gave the Trump administration a 9-0 win about the fact that if you are outside the country, the courts could not tell to the Trump administration what to do, even if he was sent there following an error. So about those kind of savage interpretations, that's putting a lot of smoke in the room and enforcing some of the legitimacy of some of the executive action of Trump. Is the Knight Institute trying to do something?
I don't know if we're taking, I see, through education. I mean, that would be, yes. I mean, maybe through our podcast, maybe that's an idea of what we should focus on. I mean, I think, well, I'm in my own echo chamber, obviously, because I'm on Blue Sky, and I'm not on X anymore, but so I don't think this represents, the knowledge base of the entire country. I mean, I have friends and family who live in other parts of the country who aren't thinking about any of this stuff. So I think for me, the main thing is seeing, Stephen Miller and other people are always going to spin, everything just to and people have done that in politics all the time. Their sort of spinning seems to be really extreme in terms of representing the actual order. But I think it is having an effect on the courts, where they actually, Department of Justice, generally the courts really respect it, and they trust that Department of Justice attorneys, if they tell you something, you can rely on it. And already you're seeing judges realizing that they can't trust the DOJ anymore. And there's all these things about you're an officer of the court. If you're a lawyer, you have an ethical duty to be truthful in court. And DOJ really has this great reputation of highest ethics lawyers, but now you're seeing the court saying, well, I'm not going to trust what you say. And that's bad for the administration. I mean, they're going to lose more. And I do think that you can see the effect of that in when the Supreme Court actually ruled at 1 a.m. in the morning of saying, instead of waiting for the usual process to play out and waiting for the government to respond, they were like, no more deportations under this law until we've ruled on it. And I think if the DOJ hadn't been making these, and it's not just the DOJ, sometimes because I listened to a bunch of these hearings, sometimes the DOJ lawyers were just like, I don't really know what's going on. Actually, in the Garcia case, the lawyer had a lot of integrity or had a lot of trust and said, I'm going to try to convince my client to do something, and then they fired him and said, no, it's totally fine. We don't need to do anything. So,
Who acknowledged the error.
Yes, yes. But it wasn't just him who, I mean, he did acknowledge it, but also the Solicitor General in the briefings to the Supreme Court said, oh, it was an administrative error. You know, I mean, so I do think people had asked me 2 months ago, you know, do you think the courts will save us? Or do you think the courts will have an ability to push back? And at the time I thought, I don't know, maybe not, you know, and in part because, you know, the Supreme Court right now, the majority is more aligned with, you know, the Republican Party by significant. But I think you are seeing pushback, effective pushback. But then the question comes to how effective if it does become a crisis, you know, if they don't if they don't follow the ruling. So. Yeah, I mean, I don't know if it's official guidance, but I've certainly read that, I don't know if it's Colombia, but other places of saying don't travel outside. If you're on a student visa or you're a green card holder, don't travel outside the United States. Now, I don't think that means everybody. I mean, probably it's more likely if you were involved in the protests, like for sure don't travel. And that's terrible, you know, I mean, that's such a restriction on people's freedom. People can't see their family, you know, because it's not just student. And yes, that people applying for visas don't have First Amendment rights, but people in the United States who have lived there for months and have student visas, I'd have to look at the case law, but have at least some rights, and green card holders definitely do. And there are a lot of people who live in the United States for years and years on a green card, but they're not a citizen, so they're sort of in a vulnerable position. And sometimes, for instance, if you come to the United States and you marry someone, you can get a green card, but you don't become eligible for citizenship for 2 years to prevent against, you know, like marriage fraud, essentially. And so people, and I think that was actually Khalil, he's in that position, and same with the student in Vermont. You know, he was going, I mean, just, it seems so cruel. He was invited to his citizenship interview, and then that's when he gets, you know, deported. But, so I think people are sending out, I mean, I did see, you know, information about don't travel. If you're coming into the United States, I mean, you know, I guess it's sort of a mixed, you know, I think you have to just figure out your risk assessment. You don't have any rights, and you have read at least some, you know, some anecdotal evidence of people trying to enter the United States to do something. There was some problem, and then they're in detention for 2 weeks. You know, so even if you're, you know, I kind of feel like, well, I don't really want to be in detention for 2 weeks. So yeah, I think that is just a really big concern. I think it's also a concern about not just students, but anyone who's sort of taken a stand or participated in specifically about, you know, the Palestinian-Israeli conflict, but who knows, maybe about other things. Definitely, yes. I think that if it were in the House can do a lot. I mean, I think most people think they're more likely to win the House than the Senate. The Senate is still just really, I mean, there's just, because of how you draw the district maps, there are just some that it's really hard to flip a seat. But so that the House could impeach him again. The House could use the subpoena power. You know, if you're in the majority, you can have a lot of hearings and subpoena information and, you know, expose things about corruption, like, you know, his whole cryptocurrency thing going on now, et cetera. Yes, it could change, but in order to actually impeach, you know, if really people thought, oh, he should be, you know, kicked out of office, you would need this significant majority in the Senate that I don't think most people think is going to happen, but it would be a lot better. I mean, having no power in any branch right now is scary and tough.
Are there ways for a Trump administration to maybe not tamper with the election midterms, but to make that there won't be any midterms? We're talking a lot about martial law, maybe, that could be declared, or... Yeah, I mean, I think all of those things which in the past I would have thought, oh, that's crazy, that's not going to happen, you know, I don't feel so confident anymore. And I think, you know, there was a point at which in first Trump where he wanted to send troops to
shut down a protest outside of the White House, and that is this huge, line in the sand. We don't do that. We don't have the military come and take action against citizens. So I think it could. I mean, I do think politically, the other reason it would be better to have at least the House be Democratic is there's just no pushback at all. There's none of the usual levers of politics seem to be working. And a lot of this stuff with the tariffs, for example, Trump is doing. And normally you might see some members of his own party saying, wait, why are you imposing tariffs? That's for Congress to do. But you don't see that because he really has the full support of his party right now. But yeah, I do. I mean, I do think people are very worried about election, and some of the, I can't remember if it passed, but there is a law to require, yes, everyone to provide identification in order to register to vote. And one of the huge problems about this is that many women have taken their husband's name and their documents don't show their birth. You have to show your actual birth name, and anyway. But then there's a whole argument of who will that hurt the most, so I don't know. I mean, which party? I mean, so much has changed, obviously, in the last year and a half. Traditionally, Columbia was known as a free speech campus and had this almost they advertised this is where the Vietnam War protests were, and people took over buildings, and I believe, when I was in college there were tent encampments against protesting apartheid, and I just felt that was part of going to college. I went to Berkeley, so there was a lot of protests there, but I don't remember exactly what the free speech rules are for Columbia. I definitely know they've made it clear, you can't build encampments, you can't put permanent or structures down. But there are still free speech zones, and I think you have to apply for certain permits, but you're supposed to be allowed to get those permits within a certain amount of time. And it's gone back and forth with how much time they will allow, because, if you say well, in order to get a permit to protest, you need to give us a month notice. Well, you want to protest when it's happening, So, to be honest, I just don't know off the top of my head where we're at with the Columbia ones, but they've definitely restricted it. And they've also just very much restricted access to campus, because there have been reports that a lot of the protests also weren't just involving the students. So there's been an effort to say, if you're on campus, you have to be part of the Columbia community. And of course, many of the protesters were part of the Columbia community, but they have absolutely, I think there was a teach-in, but they don't allow, you can't occupy buildings or interfere with teaching classes. They're trying to make something where we're protecting the usual order of academic, instruction and learning, which is our primary, mission here. I really just don't know specifically where they landed, but you can't get into campus unless you show ID or have invited as a guest. And actually, some members of the community, the neighborhood, I think, have sued them. I'm not even sure under what law, because it blocks off this big chunk of the Upper West Side. So it's just if you want to go to the grocery store, it's much more annoying, and you used to be able to walk through. But I grew up in a university town, and I grew up in Cambridge, Massachusetts, and we always walked through the campus at Harvard. That's how you got to Harvard Square. And so, I think it really has changed. Certainly since last year, the sort of it feels much more locked down. I do think there was a protest today by faculty and students about the administration's pressure on Columbia. I just saw it in the paper, so. I guess yes and no. At least I feel like we have always, we've tried to approach free speech as this isn't just a partisan issue. We're not only for Democratic or left wing versus right wing. And as I said, with the Trump Twitter case, that's something that could apply to everyone. And I'm trying to think of an example where, we said, oh yeah, you shouldn't be able to do, I can't think of an example off the top of my head, but I know that there have been. So I'm just trying to think, there was like a right-wing case where, I know. So there was this jawboning case, and it's the idea of where the government tries to put pressure on, for example, a private organization to censor the speech of another person. So a bunch of conservative people brought a lawsuit against the Biden administration saying, you're trying to pressure Facebook and Twitter to take down content that you don't like. And it was all about the pandemic, which of course became weaponized, or not weaponized, but politicized. And so there were people who had posted stuff about COVID, and their accounts were suspended because they were deemed to be disinformation. And there was some evidence that some people at the White House were calling and saying, take that down, that's terrible. It's not ironic, but it's just that one of those people who brought that lawsuit is now the head of NIH. So, so there was this huge rallying cry among the right of the platforms are biased against conservative voices. They play such an important role in the speech environment right now, and the Biden administration is trying to pressure them. The Biden administration couldn't directly censor them, but it's doing it indirectly, and they call that jawboning. And in that case, we filed a brief saying, yeah, jawboning is bad, and if the government tries to, pressure someone to self-censor or to censor someone else, or just pressures them, uses threats of force to, or threats of government action to censor speech, that's bad. So we were like, yeah, that's bad, even if, we're not taking it on a partisan view. But then you see this same group of people who were bringing and in that case they held that, yeah, that is bad, but in that specific case they had not satisfied the standing requirements, so it applies across the aisle. But now those same people are the ones going to the universities and the law firms and the corporations saying, I'm going to, we didn't even talk about, for example, I'm going to not approve your merger. Like there's this thing where Trump has sued 60 Minutes based on the interview that it aired with Kamala Harris. And this lawsuit is just so frivolous. It would just be thrown out of any court. But now the reports are that the corporate owner of CBS wants to get a merger approved from the Trump administration and may just settle this case. And it's essentially, I don't know if you call it, what you call it, jawboning or a bribe, but it's basically, a lot of this stuff that they're doing, I think, is jawboning. So anyway, I don't know if that totally answers your question, but I will say that I also think that in terms of the importance of free speech, to some extent we're getting more supporters of free speech. That I think for a while people thought free speech in the United States wasn't that important. I mean, it was not like the most important thing because often it was claimed by corporations like we can spend money and that's free speech, or it was used by corporations to strike down a lot of regulations, like a regulation saying you can't sell patient information to big drug companies. And the Supreme Court struck that down as violating the First Amendment. So I think there was a real view among the left of First Amendment has been weaponized by the right just to basically deregulate and avoid, but now you're seeing, okay, well, actually, maybe free speech is important. So I was going to end on the hopeful note that it is actually, assuming we make it this far, that it's, underpinning or underscoring the importance of free speech and how critical it is in our constitutional system.
I'm craving hope, so I think it's an excellent
yes.
and for an excellent presentation. So thank you very much.
Thank you. Thank you. Merci beaucoup.
Merci à tout le monde d'avoir été là. Et go abs.
Oh, abs? Allez, abs.
Allez, abs.
Yeah.